Moving on with our bulletin, a labour dispute between the South African Revenue Services and an alleged racist employee has reached the Constitutional Court. SARS is applying for leave to appeal against a judgment by the Labour Appeal Court that ruled in favour of the reinstatement of the employee. The employee was charged with gross insubordination and racism for using the K word with a superior. A disciplinary committee issued him with a final written warning. The SARS commissioner then altered the warning to a dismissal. The case has since been heard by the CCMA, Labour Court and Labour Appeals Court, all of whom have found in favour of the racist employee.
Chief Justice, Justices, Ms. Kazi and I appear for the appellant.
Thank you, Mr. Brainders.
Chief Justice, Justice of the Court, I appear on behalf of the third respondent.
Thank you, Mr. Grandlin. Mr. Brainders. I assume that nothing has changed. You still do not need 10 minutes within which to make your submissions without interruption.
Correct.
Now tell me, am I correct in understanding your revised position to be that you have abandoned the basis for submitting that the employer was correct to vary the sanction imposed by the chairperson of the disciplinary inquiry?
Yes. Chief Justice, you will recall that what the arbitrator found was that the collective agreement left no room for substitution of the sanction of the chair of the disciplinary by the Commissioner of SARS. The two issues on appeal, that was the one issue on appeal. In other words, was the decision by the Commissioner that substitution was not permitted by the collective agreement, was that reviewable? Chief Justice, you're correct. That issue is no longer being proceeded with by SARS. The only issue that is being proceeded with by SARS is the second issue, and that is, having come to that conclusion, was the decision to reinstate reviewable?
Well, I just want to understand how you're dealing with this thing. How do you arrive at the conclusion that the sanction imposed by the chairperson of the disciplinary committee should have been different from what it is?
That's not the question isn't what the chair of the disciplinary did. The question is, before this court, is what the arbitrator at the CCMA did. That's the question. Because what SARS did was not only to substitute the decision by the chair of the disciplinary hearing, what it did was to dismiss Mr. Kruger. And what Mr. Kruger did was that he referred the unfair dismissal to the CCMA, and it was there that the arbitrator found that the dismissal was unfair and reinstated. The question is, was that decision to reinstate, is that reviewable because the arbitrator failed to comply with Section 193 of the Labour Relations Act? As Equity Aviation says she must.
Proceed with your submissions.
Before you proceed, Mr. Brainders, is the approach you are now adopting one that is based on the proposition that the arbitration proceedings are de novo proceedings in which the arbitrator is called upon to decide afresh, irrespective of what the chairperson of the disciplinary inquiry may or may not have decided? the arbitrator must decide afresh on whether, on the evidence before him or her, the employee was guilty of misconduct, and if he was guilty of misconduct, whether that misconduct was sufficiently serious to warrant dismissal, and if he concludes that the dismissal was not or was substantively unfair, and then he or she must decide whether, in all of the circumstances, on the evidence before her, reinstatement would be appropriate. Is that the basis on which you are approaching the matter now?
Correct.
Okay.
Now, Justices, you will recall that this court in Equity Aviation held that when an arbitrator of the CCMA, the Commission, finds that a dismissal is unfair, then what it must do is it must apply Section 193 of the Labour Relations Act. And this court found that in an unfair dismissal, the primary remedy is reinstatement, except if the circumstances in Section 193(2) are present. One of those circumstances is whether the continuation of the employment relationship is tolerable. That's one of the circumstances. We say that that circumstance was present here. Now, if one goes to the arbitration award, what one will find at page 249, volume 4 of the record, 249, volume 4. What one finds at the foot of 248 is the arbitrator proceeds on the analysis of the evidence and the argument. And from 249 line 1 to 249 21, she finds that this employer, under the collective agreement that applied, was not
Live visuals here from the Constitutional Court, where a labour dispute between the South African Revenue Service and alleged racist employee is currently taking place. SARS has applied for leave to appeal against a judgment made earlier by the Labour Appeal Court, that ruled in favour of the reinstatement of this employee. Allegedly, this employee used the K word with a superior. We've got an eye on the story, and 897 will keep you up to date.